This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're talking about why an anti-concurrent cause language in a policy requires the denial of a claim, and why an earth movement exclusion is effective even though it is only a major cause of the loss, while other causes of the loss might have been covered. When one of many causes of destruction of a house was earth movement, and that was excluded, the court concluded that coverage does not exist. Ms. Lawrence, Terri Lawrence, sued, alleging that State Farm breached an insurance contract and acted in bad faith by failing to pay benefits under the contract. The case was removed to the USDC based on diversity jurisdiction, and the trial was set to begin on September 8, 2025. In a case entitled Terri Lawrence v. State Farm Fire, the United States District Court for the Northern District of Iowa on June 25, 2025, applied an anti-concurrent cause language in a policy to dismiss Ms. Lawrence's suit. Lawrence purchased a property in Sioux City, Iowa, and insured it with State Farm. In January 2023, a burst water pipe caused significant damage to the property, leading to its condemnation. Lawrence filed a claim with State Farm, but the claim was denied based on several policy exclusions, including earth movement and water damage. According to the City of Sioux City Utilities, 160 cubic feet of water, equivalent to 125,000 gallons of water, was released into the home in the January billing cycle, ending on January 6, when Florence was not at home, and an additional 90 cubic feet of water, or 67,325 gallons of water, was released in the February billing cycle, starting January 7, up until the time the water was shut off on January 11. On or about January 11, 2023, the property was placarded as being unfit for human habitation by the Inspection Services Division of the City of Sioux City, Iowa, because of major foundation and structural damage due to a burst water pipe. Prior to the pipe burst, Lawrence never observed water in the basement. After a claim was made, State Farm estimated the structural damage to be over $150,000, but denied the claim because of an earth movement exclusion. The court analyzed whether the earth movement exclusion of the policy applied to bar coverage if water released from a burst pipe caused the earth movement and subsequent settlement of the property. The court concluded that the policy's earth movement exclusion unambiguously precluded coverage even if the burst pipe was the sole cause of the property's earth movement. The parties claiming entitlement to coverage under a policy must prove compliance with its terms. The party claiming coverage may meet this burden of proof by showing 1, substantial compliance with the condition preceding, 2, the failure to comply was excused or waived, or 3, the failure to comply was not prejudicial to the insurer. The court concluded that the primary issue was whether the earth movement exclusion in the policy applies to bar coverage if water released from a burst pipe caused the earth movement and subsequent settlement of the property, making it incapable of being a house. It was condemned. The only reasonable reading of the policy, according to the district court, led the court to conclude that the earth movement clause is preceded by what is commonly referred to as an anti-concurrent clause, which excludes coverage for damage caused by an excluded peril, even when covered perils also contribute to the damage. Accordingly, because earth movement was at least a contributing cause of the damage, and clearly a major one, plaintiffs were not entitled to coverage under the policy. Because the policy's earth movement exclusion unambiguously obliged to preclude coverage, Lawrence could not show that State Farm breached the policy in some particular way, and her breach of contract claim fails, therefore, as a matter of law. Since State Farm had a reasonable basis for denying Lawrence's claim, namely the policy's earth movement exclusion, Lawrence could not prove that State Farm had no reasonable basis for denying benefits under the policy, and her bad faith claim fails also as a matter of law. So that the court concluded State Farm's motion for summary judgment was granted in its entirety. The action was dismissed. Judgment was entered in favor of State Farm and against the plaintiffs, and the trial date was canceled. In my opinion, insurance litigants must be aware of the anti-concurrent cause language now existing in almost all modern insurance policies before bringing a breach of contract and bad faith suit. Earth movement was at least a contributing cause of the damage, and clearly a major one. Plaintiffs, therefore, were not entitled to coverage under the policy, even though some of the cause of her damage was a covered peril. Earth movement was a major cause and was clearly and unambiguously excluded, and State Farm's claim denial was therefore affirmed. This video was adapted from my blog, Salma on Insurance, which is available free to anyone who clicks on the URL salma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5, sometimes 6 a week. And you'll also gain access to the more than 5,100 blog postings. You can also subscribe to these videos at YouTube or rumble.com. They're all free. And if you do, please click on the like button on YouTube or the thumbs up button on rumble.com. Please also tell your friends and colleagues about this blog so that they too can subscribe. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider, for a very small fee, subscribing to my Substack publication. Thank you for your attention.